Do employers give enough maternity leave? Should it be offered to men as well? How does Massachusetts compare to on the federal level? Well, here to answer those questions and more and talk about articles he's written on the subject is Kevin Maltby, lawyer with Bacon Wilson here in Springfield. Thank you so much, Kevin, for joining me.
Thank you so much for having me.
So let's talk about this maternity leave. You've written numerous topics or numerous articles about this topic, and it seems to be a pretty big deal. Let's start with the first difference. How does Massachusetts differ from the federal level, which is the Family Medical Leave Act?
That's right. So you have the Massachusetts Maternity Leave Act, which is a state-specific law here in Massachusetts for employees in Massachusetts. The Massachusetts Maternity Leave Act is really applicable to almost everyone, basically, and it provides leave of about 8 weeks for employees. The Family Medical Leave Act is a federal law that provides a different set of time frame for an employee, so it's up to 12 weeks, but the employer has to have over 50 employees within a 75-mile radius, and even more so, the employee has to have been working for the employer for about 1,250 hours to be specific, and they have to be there for essentially not one calendar year, but 1 year in terms of from their date of employment to become eligible for family medical leave.
Okay, and now the Mass Commission Against Discrimination, MCAD, is the agency that oversees the Massachusetts level of this law. Talk about their enforcement of it and the difference, I guess the different sides that they have to kind of look at.
So the Massachusetts Commission Against Discrimination, you think of it almost like a district attorney's office, if you will. They're an enforcement arm, they have investigators, and what really happens is that if an employee feels as though they've been aggrieved or that an employer has not given them the full amount of the leave, then they can go file a complaint at the Commission Against Discrimination. That complaint initiates an investigation. The employer will need to respond, and they have an entire process by which the parties will go through to get to the answer as to whether or not there was a discriminatory act. An aggrieved employee who actually prevails there is entitled to certain types of damages, including back pay, so wages that they lost because they got terminated because they were pregnant or something along those lines. Front pay if they can show that they would have continued to work there for a period of time, plus emotional distress damages, which really becomes a turning point in the case. It is an emotional time, and so there's a lot that the employee is worrying about. And quite frankly, in addition to that, now they have to worry about their employer maybe terminating them. So it really can be a large sum for emotional distress.
Now talk about the other side of the coin, which you're familiar with as well. You've argued for and against. Talk about the employer's side. If they were perhaps looking at firing somebody based on work performance, but then they announced, hey, I'm having a baby, that sometimes can be a very awkward position for them to be in.
Yeah, so I mean, in general, one of the most difficult questions to ask is when the employer is sitting there looking at the employee going, well, the performance has really deteriorated over time. We really need to think about letting this person go. Simultaneously, the woman comes in and says, I'm pregnant, I'm due in 4 months or so. Now that person is, quite frankly, could be protected under the Massachusetts Maternity Leave Act, and the employer really needs to tread carefully on how they handle this. Now, if they have the appropriate documentation and their personnel file is full of warnings and things of that nature, then possibly they could let that employee go. I wouldn't necessarily recommend it under the circumstances. I think it becomes a very difficult situation for all parties involved, and they should probably consult with counsel as to what to do next.
Now, the Massachusetts Commission Against Discrimination, MCAD, doesn't have specific language in the, it's not, is it gender specific? It's not gender neutral. So it doesn't, how does that affect, I guess, same-sex couples that perhaps want to take maternity leave as well?
So the Massachusetts Maternity Leave Act under Massachusetts state law is gender specific, and so that becomes difficult in terms of enforcement, but in the current climate, it doesn't make any sense. And so I'm under the impression, and from what I've seen, the MCAD will enforce the Massachusetts Maternity Leave Act equally for males and females to ensure that paternity leave or maternity leave is granted, especially if a same-sex male couple adopts a child. In that instance, then the statute provides for child adoption if it were a woman adopting a child, so the same should hold true for male partners as well.
Now, I asked the question on Facebook, do employers give enough maternity leave? Should it be offered to men as well? Most people said, no, employers don't give enough maternity leave, and yes, it should be offered to men as well, but some people said the opposite. Do you see that often, where people have differing opinions on maternity leave?
Yeah, and I think that comes down to a variety of different factors. First and foremost, your employer is going to make whatever leave policy that they want, paternity or maternity, so long as that it meets the requirement of the Massachusetts Maternity Leave Act. If they want to grant more time, then certainly they're going to do it. I've found in my practice, though, that one person, the caregiver, stays at home with the child during those really tender months, and on the other hand, the other person's got to go out and make money. So not both parents are going to take advantage of what may be available to them under the law. So it really depends on the situation, not only work-related, but also what's going on with the child as well. If it's an involved situation, then maybe the Family Medical Leave Act applies. Maybe the employee is going to just take an outright leave of absence or something along those lines.
All right. Kevin Maltby with Bacon Wilson, thank you so much.
Thank you so much for having me.